If a corporation's charter includes an exculpatory provision, that provision shields the corporation's independent directors from liability for breaching their duty of care. But the provision doesn't shield the independent directors from liability for breaching their duty of loyalty. In In re Cornerstone Therapeutics Incorporated Stockholder Litigation, the Delaware Supreme Court considered whether a plaintiff challenging an interested transaction must sufficiently plead a non-exculpated breach of loyalty claim against independent directors to maintain those directors as defendants. By way of a self-interested merger, the controlling stockholder of Cornerstone Therapeutics Incorporated obtained all of the corporation's remaining stock. Cornerstone's interested directors and independent directors approved the merger. Cornerstone's certificate of incorporation contained an exculpatory provision pursuant to Section 102b(7) of the Delaware General Corporation Law. Under this section, an exculpatory provision shields independent directors from liability for breach of their fiduciary duty of care. Stockholders of Cornerstone challenged the merger before the Delaware Chancery Court. The stockholders included the independent directors among the named defendants, alleging they breached their fiduciary duty of care. Because the merger was a self-interested transaction, the applicable standard for the court's review was the entire fairness standard, which required the court to scrutinize the whole transaction to ensure it was fair. The independent directors filed motions to dismiss. They argued that because the corporate charter's exculpatory provision shielded them from liability for the duty of care claim, to maintain an action against them, the stockholders were required to allege a non-exculpated claim that the independent directors breached their duty of loyalty. The Chancery Court denied the motions, finding that pleading non-exculpated claims was not required based on the court's reading of Delaware Supreme Court precedent. But to ensure its reading was correct, the Chancery Court certified the question of independent director liability to the Delaware Supreme Court for interlocutory review.